Welcome everyone to today's workshop, 5 critical steps you must take to plan for your child with special needs. We thank you for being on today. This workshop is being recorded and all participants will receive a link to the recording within the next few days. My name is Patricia Clay and I am the Director of Operations and Client Services here at the Law Offices of John K. Hilton. So before we get started, let's take a minute just to make sure you can hear us and see our screen. So in the question box, please type the number 1 if you can hear me. Great, it looks like you can hear me. If you cannot see my screen, will you please type the number 2 in the question box? Perfect, it looks like everyone can see my screen. Okay, so let's get started. With the overload of people on the internet, sometimes screens can freeze up, so we appreciate your patience if this happens. There will be a question and answer period at the end, but John's workshops are interactive, so please feel free to post in the question box at any time, and we will answer your questions to your posts. Finally, John is going to be offering a special gift to you, so please stay to the end and hear about this gift. Again, thank you so much for attending today, and without any more delays, I'd like to welcome John Hilton.
Welcome, everybody. Such a great time to be here talking to everybody. Before I do anything else, I'd like to make sure that you've had the opportunity to download the workbook that should be in your toolbox on the right-hand side. It's a PDF form. I believe it says 5 Steps Workbook. If you have not downloaded that at this point, I encourage you to go ahead and download it, and if you can, print it out, because this is an interactive workshop, as Patricia said, and I'm going to be asking you to think about your situation, about the people in your family who might need this, and to make notes in your workbook to help you remember the concerns and issues and responses and answers to those questions that we're going to be addressing today. So do that now if you haven't already, and we're going to get started. On your screen, you should see a picture of my son, Anthony. Anthony is 30 years old. He has autism and several other disabling diagnoses. Just a wonderful, wonderful guy, all in all. And you can see when you just look at his face, he has a great sense of humor, and he enjoys life to the fullest extent of his ability. But while I talk about Anthony and my experience with him growing up, I'd like for you to take a look at your workbook. On page 2, or is the first page after the cover page, and it should say My Reality at the top of that. So go ahead and start working through that and list the people in your life who have special needs, just like my son Anthony. Who is your Anthony? And start answering those questions that you see in your workbook about your reality while I talk about Anthony. You know, when we knew about Anthony's diagnosis pretty early in life after several missteps and misdiagnoses, but we always knew that he wasn't going to have a normal life. And you know, it's just one of those things that over time, there was this constant nagging concern and worry in my mind about what would happen to Anthony if the worst happened to his mother and me. You know, where would he end up? Would he end up in an institution somewhere being cared for by strangers who didn't understand his unique needs as a child or an adult with autism. And, you know, people would tell me, you know, things like, well, you need to make sure you've got the right insurance, or have you set up a savings account to make sure that you know, there's money to take care of them if you're not around. Well, you should set up a trust. You know, and I was like, well, I don't even know what this stuff means. Who do I talk to? What kind of insurance? Can I afford insurance? Who do I talk to about setting up a trust? That sounds like maybe I should go talk to a bank. I'm not really sure. And I was overwhelmed by the confusion of all of this advice. And keep in mind, this was before the days of Google and the internet. So we obviously we have so many resources today that make this so much easier. But back then, we didn't have that. Showing my age here, but you know, this was, you know, 20, 30 years ago. And so we didn't have the ability to just pop onto Google and say, you know, how do I set up a trust for my child with autism? And even with the advent of the internet and Google, you know, what I find talking to parents of children, you know, with special needs like Anthony, is that they're still overwhelmed by the confusion. They still don't really know how to move forward. And I can totally relate to that. And I wonder if you guys, if any of you out there can relate to that question, go ahead and enter the number 1 in the question box. Are you overwhelmed at times by all the information out there and don't know where to start and are concerned about getting everything done correctly? Right, yeah. So I see some of you are entering, you know, number 1. You've shared that same concern. And then I'd also like for you to, in your question box, if you have a child with special needs under the age of 18, go ahead and enter number 1 in the question box. All right. Yeah, so some of you have children under the age of 18 with special needs. How many of you have an adult, someone over the age of 18? If you do, enter the number 2 in your question box. Okay, so we can see that you know, this is true for many people. Some of you have children under the age of 18. Some of you have adults with special needs. Here's another question. If you have other children under the age of 18 who do not have special needs, who are what we often consider neurotypical, go ahead and type in yes to your question box. All right, so we can see that the entire spectrum is covered here. We have children, we have parents of children with special needs under 18, parents of children with special needs over the age of 18, and we have parents of children under 18 who do not have special needs. And I want to assure you that what we're going to talk about today is going to address all of your children. It's going to address your adult children, your minor children with and without special needs. So I hope you're working on your workbook and that you're kind of working through the My Reality box as we move forward. So this is what my path looked like when I first started this journey of planning for Anthony. I could not see what was around the next bend. It was rocky. There were hazards. I just didn't know what would happen next. And I had to take it step by step, one at a time, to try to figure out how to make this happen. But here's the great thing. I did it. And I've walked down that path. And now this is what that path looks like for me. And this is the mission that I have now, is to help others be able to take this journey with me on a path that looks like this. That's straight, narrow, with a clearly defined goal in the future, where you can see the horizon. And so that's why I do these workshops, because my mission and my passion to educate other families of children with special needs about how to take this journey and not be overwhelmed by the confusion that many of us has experienced, and by that narrow, crooked, rocky, foggy path that I embarked on when I started doing this for myself. Now, just to give you a quick history about myself, you know, I came rather late into the legal world. I was a paramedic for 20 years. I worked as a chief operations officer at a hospital. Then I decided to make a change in life and become an attorney. And I had the fantastic opportunity to work with some really great law firms in Tucson, two of the larger law firms here, and worked with some amazing, fantastic attorneys, and I was mentored by some great people. But one of the things that I discovered was that the law firms and how they deal with clients did not match up with my vision for how I wanted to work with clients. Many of them were based on the billable hour, and so you never really knew how much it was going to cost to hire an attorney. I saw that the estate planning attorneys I worked with were all about the documents and the transaction, and they didn't really take into account the entire scope of the client's life and make sure that everything was done correctly, and that if they had a trust, for example, that all the assets were properly transferred into the trust, so the trust actually worked when the family needed it. And then the other thing I saw was that once the transaction was complete and they had handed off the will or a trust to their client, the relationship ended there. That transaction was over and they moved on to the next one. So when I started my firm, I made the decision that I was going to do things differently. I was going to do things my way. And so first thing I did is I said, I'm not going to charge by the hour. So our estate plans are all flat fee, exactly what it's going to cost and what the value to you is going to be for that fee. Secondly, when we do estate planning, I determined that the one thing I was going to do is I was going to make sure that I took in the entire scope of the family's dynamics and values and needs and understand their family story, so that I could craft a tailor-made plan specifically for their family that works for them. And I would make sure that everything worked together, including making sure their trusts were properly funded, that if they created a will, that all of their beneficiary designations on their home, on their life insurance, on their investments and retirement plans, that everything worked together so there were never surprises for their family when that person died or became incapacitated. And lastly, I determined that absolutely my practice was going to be built on building relationships with my clients over the years and making sure that we came back and visited over and over and over again to ensure that their plans continue to work for them. Because the reality is that the laws change and your life changes. In fact, there have been significant changes in the law in 2020 that have completely changed how we are drafting and designing our plans. And so, that's going to happen again. And when that happens, we need to be able to get a hold of you and have that relationship with you to say, hey, there's been a change in the law. Let's make sure your plan still will work for you when your family needs it. So I'd like for you to just kind of look at some of the results we've had. This is a client who has a daughter with autism, and he just wrote to tell us that we owe you all the thanks for helping to ease one of the many big burdens in life. He shared the same burden I had, wondering what would happen to his daughter if anything were to happen to him and his wife. And then here's another client who said, thanks for all you have done for me. I can't tell you how secure I feel having all in place for my loved ones. That's the beauty of estate planning, is that it gives you that sense of security and knowing that your loved ones will be taken care of. So I want to kind of get started. In everything that we talk about today, there are 3 underlying principles that you must keep in mind, and I'm going to ask you to embrace these principles for you yourself. The first one is At all times, we must keep our children out of the homes and the homes of strangers. If you agree with that, type the number 1 into your question box and say, yes, I agree. We've got to keep our children out of the hands and homes of strangers at all times. That's not acceptable. The second principle, you must provide for the care of your child throughout their lifetime. Now, this is a shift for many of us because most of us who have normal or neurotypical children, I should say, we look forward to the day when they turn 18 and they go to college and they get the jobs and they're out of the house and we no longer are required to support them. But when you have a child with special needs, that burden shifts, and now it's your responsibility to make sure your child is cared for throughout their entire lifetime. And today, that means that more than likely, your children will outlive you. That wasn't always true, but with medical advancements and technology, for most, we know that our children have a very high likelihood of outliving us, and we have to make sure that we've provided for their care throughout their lifetime, even when we're no longer around to do so. The third underlying principle, you have assets that are more valuable than money. And I'm going to talk more about this as we move through this presentation, but I want you to understand that that is underlying in all of this. We have clients come in who say, I don't have much, but I want to make sure that my child's taken care of. Yes, you do have a lot more to offer your children than just money. And I want you to embrace that and keep that in mind. So I want you to ask yourself as we move forward here, 3 simple questions. First, what would happen to your child with special needs if you did not come home today? What would happen to your other children if you have neurotypical children who do not have special needs as well? What would happen to them if you didn't come home from work, from school, from the store? What would happen to your children? And lastly, what about your most treasured belongings? And I use the word treasured belongings because I think it's a kind of a broad thing. That can be anything from your heirloom, so what should I say, dishes from your grandma that you want to make sure goes to a daughter or daughter-in-law. It could be anything. This is unique for every person, and it's what's treasured to you. What would happen to those items? Okay, so keep those in mind, and let's start talking about the first question: what would happen to your children if you did not come home? So typically right now, you probably don't have a plan for what would happen to your children in the short term, but let's kind of do a hypothetical. So let's think about it. You leave your kids at home with a caregiver or a babysitter. You might leave the caregiver your cell phone number, maybe your neighbor's phone number, but if something happens to you, you can't answer your cell phone. And if your neighbor does not have specific legal designated authority to take care of your children, the police would risk liability by leaving your children in your neighbor's care or in your caregiver's care. They don't have a choice. The only thing they can do is call in Child Protective Services to care for your children, or Adult Protective Services, as the case may be. So let's look at this on a very practical level. You've left your child, whether they have special needs or not, in the care of a babysitter or a caregiver. And something happens to you and they can't get a hold of you, and so eventually the police are called because they can't find you and they can't get a hold of you. The police will eventually locate your children either at your home or at school, and if you haven't designated a clear person with specific legal authority to stay with your children, then the police have no option but to call in Child Protective Services. And Child Protective Services will have to figure out what to do with your child. Typically what will happen is they'll take your child into custody until they can figure out how to ensure that your child can be kept safe, because that's their job. Child Protective Services is to make sure your child is always safe. Give you a very quick example of this. Back when I was a paramedic, I responded to a rollover accident with as a single vehicle, and when we got there, the mother or the driver had been killed in the accident, and in the back seat was a young girl, I'd say probably around 14 years old. She was blind. She had other developmental disabilities, and all she kept saying, was mom, mom, mom. She had no idea what had happened. She was traumatized, and we couldn't figure out who to call. So what's our one option? We had to call CPS to make sure that that blind, disabled child was taken care of, because the police couldn't take care of her. We couldn't take care of her. We didn't know who to call. So that's just an example of one of the things that can happen, whereby your children could end up in the care of a stranger because CPS has had to take them into custody and place them in a temporary home. And as a father, when I thought about my children, I have 3 children from my first marriage, and I have Anthony, who has autism. I have 2 other neurotypical children. And the thought of them being taken into custody by the authorities, cared for by strangers, even if it's just for an hour or so, or even, it could be even, up to a week or 2 weeks, 3 weeks, until the courts figure out what to do, and not understanding what's going on, especially Anthony, that scared me to, just terrified me. And I couldn't imagine allowing that to happen, but I didn't know what to do about it. I didn't have any tools at hand. And so I lived with that fear. And I know you don't want that to happen to your children. So in a few minutes, we're going to talk about specific steps you can take to make sure that you avoid that scenario. Now let's talk about what would happen in the long term with your children. So even if you haven't made a plan, there is a plan for your child, but you're probably not going to like it. Let me tell you a story that will help to illustrate why it's so important to designate who you'd want to take care of your children in the long term. And this is a hypothetical. Let's assume there are 2 people who would want to raise my children if something happened to me. We're going to call them my hypothetical sister and hypothetical sister-in-law. My hypothetical sister is 26 years old, lives in Scottsdale, Arizona. She's not married. She's never had children. She still likes to go out to bars and clubs and generally has a good time. My hypothetical sister-in-law is 38 years old, owns her own home, has 3 children over the age of 9, has a steady job, works at a bank, and she lives in Tucson, Arizona. Now, you get to be the judge. You've heard the facts about my sister, single, likes to party, and my sister-in-law has a stable life. And so who do you think the court would choose to raise my children? If my sister, the single party girl, or my sister-in-law, the stable, married, has grown children, they both petitioned the court to raise my children, who do you think would win? And of course, let's just see. If you think it should be my sister, go ahead and enter 1 in the question box. If you think it should be my sister-in-law, enter 2 in the question box. And there you go. Of course, my sister-in-law. That choice is so obvious, and yet for me, that choice is so wrong. Let me tell you why. The last person I would want raising my kids would be my hypothetical sister-in-law. Not because I don't love her, I do, but because in my heart, I know she would not parent my children the way I would want. Whereas I know that my hypothetical sister-in-law, despite her circumstances, would change her life and raise her children the way I wanted them raised. A court would never be able to judge that and know that. And in the worst case scenario, my sister and sister-in-law could end up fighting about who would raise my child or my children. And so they end up in court. And during that time, where are my children? They're probably in foster care while the court figures out who ends up caring for my children. Obviously, a worst case scenario, but it's not necessary. There's a plan for that. So we're going to talk about how to avoid this scenario in just a few minutes. Now, so that's talking about, one of the issues that comes up with guardianship and your children and making sure they never end up in the hands of strangers. I'd like to shift gears just for a moment and let's talk about some fundamental legal concepts. And this is the process called probate. And this is the state's estate plan for you. If you don't do any planning and you don't create a will, you don't create a trust, well, the state already has a plan for you. And it's called intestate probate. So if you have no estate plan and you become incapacitated or you die, this is the state's plan for you. And it involves going to court so that a judge can appoint someone to make decisions for you and or give your family access to your assets or direct where your assets should go. If this is about creating a guardian for you or for your children, then this is called guardianship. If this is about transferring your assets after you die, then it's called probate. Either way, the process is the same and it all goes through the probate court. So the court decides where your money goes, and it may not be who you would want it to go to. And we're going to discuss why that's so true in just a moment. And it has to do with the fact that your child with special needs, once they turn 18, is an adult. And the courts don't look at whether or not your adult child has a special need or not. 18 years old, they're an adult, and they could end up receiving your assets in a way that would really harm them in the future. So here's the thing, even if you do have a will, this exact same process applies to you. And so here's the trap or the trip through the pipe, if you will. There's a lot of leaks in this pipe where your assets and your money is going to be pulled out of your estate before your children ever see it. There's going to be attorney's fees, possibly executor's fees. Your property may have to be appraised, and there's going to be appraisal fees. If a court appoints a personal representative or an executive for a state, they may have to post a bond, which is expensive as well. You have to pay off your creditors. You have to pay court filing fees. This whole process is expensive, and it's slow, and it's time consuming. Now, in Arizona, we talk about being, expensive and slow. You're talking at a minimum of 9 to 12 months to get through this process. And during this time, your loved ones, your family may not have access to your assets other than a small allowance that the court will allow while this is all figured out. So who would you rather have immediate access to your family, your creditors or your children? Okay, so in your workbook on page 2, there's a box that's called My Current Estate Plan. Take a quick moment and check the box that is appropriate for you. So let's take a quick moment and talk about what constitutes your probate estate. If you die with a will or without a will and your family ends up having to go to probate, what will go into that? And I invite you to work along with me on page 3 of your workbook. There is a box called probate. And first of all, I want you to kind of look through there and say, based on everything I just talked about, what concerns me about probate? And then we're going to move down to the box called My Assets. And we're going to calculate your estate. And I'm going to show you an example here of a common estate that families will come in to see us with. So typically they'll have a family home. Very often the fair market value of their home is around $200,000. But they have maybe $100,000, $125,000 worth of equity in their home. They're still paying for it, but they got some equity. And often they'll have, a bank account, they'll have some investments, some stocks and bonds, things like that, maybe worth about $15,000 in total. And they'll have some personal property. Now, personal property includes things like your vehicles, your furniture, your computers, electronics, maybe your jewelry collection, guns, things like that. And so when we add all that up, we often come up with a value of about $80,000 in total personal property. And so while we're doing this, look at your workbook and very quickly, to the best of your ability, figure out what the value is in your mind of your assets while we go through this. And then very often we'll have clients who have a business, and often it's a side business, and maybe they have some personal assets or some assets in the business, such as equipment, contracts that are still paying, things like that. And we can value that business at around $30,000. And many of our clients have life insurance. Most of them don't have huge policies. Very common to have about $100,000 in life insurance. And you'll notice that this life insurance policy, I've scooted it all the way over to the right. And that's because usually life insurance is not passed through probate, because typically you will have named a specific beneficiary for your life insurance, and it'll go directly to that person without having to go through the court process. So let's add it up. In this scenario, we're looking at a probate estate of about $250,000, and this is not unusual for many of our clients. But here's the deal: to go through probate, your family is going to have to pay anywhere from at least $3,500 to $6,000 to get this through the court system. Remember that pipeline we showed you before? All those leaks in it, this is what that adds up to. And we said it was a slow process, 9 to 12 months minimum to get through this process, during which time your family has very limited access to that $250,000 in assets. And this is a public process. That means that all of your records are available to the public, because this is considered a civil law thing, a civil court, and anybody can get access to your records. They can find out who your assets are going to, what assets you have, and in today's market, what that means is that we have very unscrupulous people who can target your children and your family with scams and things like that. So the big question is always, but who will take care of your children during this process? And here's a scary thing. For your child with special needs, receiving your assets at age 18 could very likely disqualify them from government benefits. And there are many reasons that we can't talk about today for lack of time, but there are many reasons that whether your child needs it today or not, you want to maintain eligibility for your child for their lifetime, because you don't know what will happen in their future. And so, getting assets at age 18 and getting those assets unprotected, even for your children without special needs, imagine them turning 18 and getting a large distribution of assets. What are they going to do with that? And how scary is that to think, does your 18-year-old child have the financial maturity to know what to do if they receive a large amount of assets or a life insurance payout? So we're going to talk about this and what to do about it here in just a moment. Now, for children with special needs, the question often comes up, well, how will my child receive assets after I'm gone? And there are several ways this could happen. Number one is an outright gift from family member. And that doesn't mean, well, grandma sent me, $10 for my birthday. What often happens is we find that grandparents, especially, really wanting to make sure that their grandchildren with special needs are taken care of, will leave them, for example, cash in a bank account, and they'll do a beneficiary designation on that bank account saying that when I die, all this cash goes to my grandchild with special needs. or they'll create a will and leave assets to their grandchild with special needs in the will. They'll do beneficiary designations on a home or stock, anything like that. And as we already know, if your child with special needs gets anything like that, their eligibility for federal benefits and state benefits may be severely impacted for a very, very long time. The other possibility are ABLE savings accounts, and we'll talk about that in a moment. Maybe can you pass your assets to your child with special needs in your will? Does that work? And then we're going to look at a supplemental, or what we call a special needs trust, and see if that would be a good option for your children as well. So let's talk about, what if your child receives a gift from a family member? Well, first of all, they cannot receive cash until they're 18 years old. And so that's not going to really help them out all that much if they're still a minor. And if that gift results in your child having more than $2,000 in assets, they can lose their state and federal benefits, either temporarily or in the long term, depending on the situation. Those kind of things really harm our children. This is a picture of my son. He had to have significant facial correction surgery. And if he had lost his benefits, this would never have been possible. And so it's very important that we protect those benefits. And so, receiving cash from a family member is probably one of the worst things that you can do for your child. So then, let me back up. We talked about an ABLE account, and Arizona adopted the ABLE Account Act, I believe it was in 2016. Very, very beneficial program, but it's not right for everyone, and it's not right for every situation. It's called the Achieving a Better Life Experience. That's where they came up with the ABLE acronym. But your child must have been diagnosed before age 26. The total amount that can be contributed to an ABLE account in any 1 year is $15,000, and that's cumulative from all contributions. If that account reaches $100,000 or more, then your child can lose benefits. And it must be opened by the disabled person themselves, a guardian, or a financial power of attorney. Here's the kicker. If you use this as the sole means of supporting your child with disabilities, when your child dies, Medicaid becomes a creditor to your ABLE account, and they can take virtually every dollar that's left in that account to pay back everything they've ever spent caring for your child. So if you've been diligently placing money in there and you've got $100,000, $95,000 in there, and your child dies, all that money is going to go potentially to Medicaid. So it does have drawbacks that have to be taken into consideration. So what about leaving assets to your child in a will? People say, ask me all the time, isn't that okay? Well, let's talk about what might happen. First of all, if you leave your assets to your child in your will, it's only effective upon your death. So the question becomes, what happens if you become incapacitated? What happens if you have a stroke or a head injury, or you develop a mind-altering disease, such as a very common one, dementia? How will your child be taken care of when the only way they can get assets is if you die? And if you leave your child more than $2,000 in assets on your death, then they're going to be disqualified from some state and federal benefits. And whatever you leave for them will not be protected from creditors, from scammers, from judgments, things like that. So all of that could be taken away from your child in some of these negative situations. Another big thing, and we see this all the time with people who do their own wills. They go online and do a will, or they talk to an attorney who doesn't really specialize in estate planning, and their will does not address the guardian or conservator for their child with special needs. And so that the result of that is that your family ends up in court, ended up fighting over who's going to be the guardian or conservator of your child. And here's a really big one. Does your will provide instructions for caring for your child with special needs? And, we all know that every child is different, and especially your child with special needs. And you know your child, you know what makes them tick, you know what sets them off, you know what works and doesn't work. Nobody else is going to know that. And that's probably one of the most important provisions you can put in your estate plan, is making sure that somebody, whoever would be guardian for your child, has instructions and understands your child as best as possible the way you do. And ultimately, the big question is, who will care for your child? Does your will ensure that the person you want, who will take care of your child the way you want, will ultimately be responsible for your child? And how can you be sure, especially in a will? So there is a way to be sure, and we're going to talk about that in just a moment. So let's look again at why a will may not work. So here's the situation. You've created a will, you die, and remember we talked about probate? We talked about it a few times now, that slow, expensive, time-consuming, energy-consuming process. Your will is going to go through probate. And during that time, your child may not have access to your assets. And so your child's waiting for the support that they need for the court to approve distribution of assets. And when they do, more than likely your child will lose eligibility for state and federal benefits. Okay, so a question just came in. What happens if I leave my assets to another sibling to care for my child with special needs? This is a great question, and it's a common question. Let's look at what would happen. So your child with special needs has a sibling, and you leave all of your estate to your sibling with instructions: take care of your brother or sister with this money. Half of it's for you, half of it's for them, but I don't want them to lose their benefits, so I'm going to leave all of it to you. Well, let's look at what happens to your neurotypical child, the sibling who's been tasked with taking care of their brother or sister. What if your child gets divorced? Now, Arizona is a community property state. Immediately, 1/2 of those assets that you left to your neurotypical child could be taken in that divorce under the community property laws. What happens if your child develops credit problems and has to file bankruptcy? The bankruptcy court can go after that entire inheritance to pay back those creditors. Or if your child is sued, the court can put a judgment against the entire inheritance that you left for your child, and both of your children could be left with nothing. So that's one of the reasons that we don't, encourage people to create a will and leave everything to a sibling to take care of their brother or sister with special needs. And then one of the other things that often happens is, we're all human. And what if the sibling develops financial hardship, just like what we're in today? They lose their job, they're about to lose their house, and there's $100,000 sitting over here designated to take care of their brother or sister with special needs, but they're going to lose their house if they don't make their mortgage. The human thing to do is to rationalize and say, I'm just going to borrow $1,000 so I can pay my mortgage. I'll pay it back. And how many of you have borrowed money from a 401k and never paid it back, despite your best intentions? And so, those are some of the risks with leaving your assets to a sibling with instructions to take care of their brother or sister with special needs. All right, so I've laid down some foundations. We talked about some of the legal things, about probate, about wills, things like that. Why a will may not be enough. We've talked about guardianship. Let's start talking about what to do about it. These are the 5 critical steps that you must take to care for or plan for the future care of your child the right way when your child has special needs. So we already went through this. I'm not going to do it again. Choose the right guardian. You guys said overwhelmingly that we should choose my sister, but we said ultimately it was my sister-in-law to be the best person, I believe, because she was the actually it's the reverse, my sister, because she was the one who would raise the child the way I would want the child to be raised. But let's talk about how we then make those decisions. On page 4 of your workbook, this is step 1, is name your guardians. And I'm going to go through this quickly. You will not have time to keep up with me, but I want you to look at this, and as we're going through this, kind of start the process in your mind so that you can remember how to come back to it and complete it. So how do I decide? The first thing you want to do is create a short list of people that you believe in the long term would raise your children for the rest of your life, or I'm sorry, the rest of their life in the way you would want. Okay, so you know the big mistake people make is like, well, you know, I want it to be their brother or sister because I don't want to burden anybody. And I want to encourage you to really look outside of that. Maybe you have living parents or siblings. Those are good choices. But other good choices are things like friends, people who your children maybe have grown up with their children, and they know these people well, and they would be comfortable being raised by your friends. You know, some benefits of that is often your friends live locally in your same neighborhood. And so your children wouldn't have to be moved across the state or across the nation to live with somebody else. Think about your aunts, your uncles, your cousins. Godparents are a great choice to name to raise your child if something happens to you. Even nieces and nephews and college roommates that you've kept in touch with over the years. And you know, I mean, many college roommates have very, very close relationships and would be more than honored to say, yes, if something happens to you, I'll make sure that your child is raised in the way that you want it to be. Now, here's the key. Anyone is better than foster care. Anyone is better than a stranger. So even if you don't have great choices, look at your best choices, because anyone's better than having your child end up raised by strangers in a foster care system. So the second thing you want to do is consider your top 3 parenting values. What's most important to you? You know, when we say, you know, find somebody who will raise your child the way you want them to be raised, what are those top 3 values that you consider when you think about that? And here are some ideas to kind of spur your thought process. I'm not going to go through all of these for the sake of time, but you know, what is their relationship with you? Where do they live? Do they adhere to your religion or your spiritual beliefs? Do they adhere to your morals? Do you want your child to be raised by a typical married couple, or does it matter to you if maybe your friends are in an atypical relationship, same-sex marriage, things like that? So these are all things that you can think about as how do you want your child to be raised, and pick the top 3. The next thing you want to do is you want to compare your short list, you know, 5 people or couples that you want to raise your children if something happened to you, and your top 3 parenting values, and you want to rank them. So who in your list most closely adheres to those top 3 parenting values, and rank them 1 through 5. So that you have your top choices there. And then you want to look at, well, what if I named a couple? You know, what if one of the couples is my sister and her husband? If my sister died, would I be comfortable with her husband raising my children alone? If my sister and her husband got divorced, how would that work? And so you have to make a decision. Is it my sister and her husband either together or either one of them? Is it my sister and her husband only as long as they're still married, but if something happens to my sister, then somebody else should step in, those kind of questions. And so you look at your worksheet and decide what works best for you when you're talking about a couple who you've selected to be guardians for your children. Then you're basically done. That's your priority permanent guardian list. Okay, and so the next thing you want to do is say, well, okay, I did the long-term guardians. What about that short-term thing? John talked about that a while ago, that if something happens to me and I don't come home and the police come to my house and they have to call Child Protective Services, how can I avoid that? Well, this is what you're going to do. You're going to name guardians for the short term. And who should those be? Well, we recommend that first of all, it's someone you trust. Now, this could be someone, for example, your pastor, a teacher, a principal, a neighbor, even a babysitter who's over 18, someone you trust to care for your child, your minor child, explicitly, and who lives within 20 minutes of where your child is. Somebody who can get to your child quickly. Should be someone who cares about and can comfort your child, because during this time, your child's going to be confused, because guess what? They can't find mom and dad, and your child's going to be confused and worried and upset. And it should be someone that your child knows, loves, and trusts, so that they have the benefit of going into a home or being with somebody that is not going to stress them out even more and confuse them even more. Now, this is all great, and you can choose those people, but it doesn't work unless you provide proper legal documentation that allows your first responders to take custody of your child. Remember, we said if the police show up and there's nobody there with legal documentation to take custody of your child, they have no choice but to call CPS. So you choose these people, and then you have to provide the proper legal documentation. And we call this our Kids Protection Plan. And we're not going to talk about it in a lot of detail today, but you do want to ask us about that later if you have minor children, and we'll tell you, because this does require an attorney's intervention in order to get that legal documentation done. So let's talk about guardianship. Actually, before we do that, go to your workbook, page 5. And there's a section there called Guardianship of My Minor Children with Special Needs. So if you have a minor child with special needs, check off every box that is true for you and that expresses your thought and sentiment about how you've planned for your child with special needs. Now let's talk about guardianship of your adult child with special needs. So when we talk about guardianship, there are several questions that I like to ask clients. One is, will your child be self-sufficient as an adult? And that's a very broad question, but we cut down and say, well, will your child be able to make personal, financial, and personal care decisions? Can they live independently or semi-independently? Can they manage a bank account? Are they able to hold down a job and shop for their own personal care items, groceries, and things like that, despite their disability? And if so, they're not a candidate for a guardianship, but maybe they need some alternatives to ensure their safety and well-being. And so, first of all, when we talk about guardianship, we should understand it is a court process. You cannot appoint a guardian of an adult without the court intervening and approving the person that you have appointed. But you can nominate your first options, and the court will give great weight to your nominations. But maybe your adult child doesn't need guardianship. There are some alternatives. We can do like a limited guardianship where we ask the court to have a guardian over certain aspects of your adult life rather than full control. Maybe it's just a conservatorship. In Arizona, conservatorship allows a person only to control the adult's financial affairs, but has no say in where the adult lives, who their friends are, that type of thing. Maybe that's not even required. Sometimes, and many of you may already do this, maybe you're a representative payee with the Social Security Administration for your child's benefits. You receive their pay and you're responsible for using that money for the care of your child. Now, despite any of that, if your child has the mental capacity, the one thing that they absolutely should do is complete their own advanced healthcare directives and power of attorney, if that's applicable for your child. And you might want to speak with an attorney about these things to make sure that your child has the capacity to do that, and to make sure that it's crafted appropriately for your child's specific situation. Okay, so knowing that, and after hearing that, go to your workbook on page 5 where it says guardianship of my adult child with special needs, and answer the questions there that most closely represent your situation. All right, so we've talked about making sure that your child stays out of the hands and homes of strangers, and they're always cared for in a way that you want by the people that you want. Okay, so that was the first critical step and the longest step. So we're going to move on to step number 2, which is that you must provide financial resources for your child with special needs. Because remember what we said, it's your responsibility to provide for your child with special needs for their entire life. And this is a very sobering and often difficult area for many parents to consider because it's difficult and we often don't know how to make this happen. So the first question I like to ask parents is, have you created a life care plan? And many people don't even know what that is. If you do one independently, it can be very expensive to have an independent consultant come in and do a life care plan. But many of the better life insurance providers will do a life care plan at no cost to you to help you determine how much life insurance you may need. And I know that New York Life, I know specifically an agent here in Tucson who specializes in life insurance planning for families with special needs. And he'll help you do a life care plan at no cost. And I believe it's, I can't remember the name of the other life insurance. They have an online life care plan worksheet that you can go through. The reason you want to do this is we often and almost always underestimate how much it's going to take to care for our child for the rest of their lives. And so, you know, for many of us, we simply do not have the resources outside of life insurance to make sure our children are cared for. So all in all, I recommend to people, if you can qualify and if you get life insurance, it is the best way to ensure that if something happens to you, your child will have the resources they need to care for them for the rest of their lives. Now, part of this also goes into creating a special needs financial plan. And there are financial planners out there that specialize in helping you manage your resources and investments in a way that will ensure that your child with special needs has the resources that they need, and in a way that will not compromise their eligibility for benefits. And then also you should always look, what are other sources of support? You know, things like foundations, you know, public and private sources of support in foundations and charities, things like that. You know, look for anything in any way in which you can bring in other sources to help make sure that your child is cared for the rest of their life. Now, you know, if you look on page 6, it says provide enough financial resources. And I want you to kind of quickly look it through there and the box is appropriate for you, and then go down to the action steps and say, okay, based on what I said before, what do I need to do now to make sure that I have provided financial resources for my child for the rest of their life. So we've covered keeping your child out of the homes of strangers. We've covered making sure that we provided for the care of our child for the rest of their lives. And now we're going to get to that third underlying value or principle, is that you have more to pass on than just your assets. Now, that doesn't mean that you don't pass on your assets. So we're going to talk about passing on your assets, and then we're going to move on to some other ideas as well. So as we go through this, go ahead and go to page 7 of your workbook and start completing step 3. It says planning for my death, and check the appropriate box that describes where you are today. Do you have a will? Do you have a trust? Maybe you don't have a will, but you're fine with that. So check where you are today. If you do have a trust, then you're going to move down to the second half of that page where it says my trust, and you're going to start filling that out. So here's the thing, not every client needs a trust. Some of you might just want to avoid that probate process, that year and a half, 2-year court process, the cost of it, the time and energy that somebody's going to have to put into making sure that happens. Maybe you want all of your assets to pass absolutely privately so that they avoid the probate process. If you do, then a trust is one of the best tools you can use to accomplish that. Maybe you do have a few assets. You want to make sure that your child receives their assets in a way that's protected from divorce or from bankruptcy or for a lawsuit. A trust is the best tool to accomplish that. That being said, we create will-based plans for many clients. So we're not here just trying to sell trust, but we will only do a will-based plan for a client after we take a very careful look at their assets and get to know the client's wishes, desires, and values. And then we educate them to make the best choice after we've looked at all of that. Many people don't know about trust, and they come to the office and say, I need to prepare a will. And I just won't do that until we sat down and looked at everything and make sure they're fully educated to make the best choice to accomplish their goals for their family. So what's the difference between a will and a trust? A will has to go through probate. In a trust, your assets pass outside of probate. A will is time consuming, 9 to 12 months minimum. In a trust, your assets pass almost immediately to your beneficiaries. There's a cost at the time of probate. We talked about $3,500, $6,000, and with a trust, that cost is minimal. We're talking, in the neighborhood of hundreds of dollars to transfer the assets and appoint a new trustee. Your will is public. Assets that pass to a trust is absolutely private. With a will, you know that your beneficiaries at the age of 18 are going to receive their inheritance. With a trust, you get to determine when and how your beneficiaries get their assets. If you want it spread out over time, if you want it immediately, if you want it protected from divorce and creditors and lawsuits. So you can kind of see there, which appeals to you, the will process or the trust process. Now, with the issue of the will or trust, you still need those related documents. Everybody should have advanced healthcare directives and a power of attorney set up, whether you have a will or a trust. If you have minors with or without special needs, you need that kids protection plan in place to make sure that in the short term, they don't end up in the hands of strangers. And you should have that long-term guardianship paper if you have minors or if you have adults with special needs. So go to page 8 now and look at what is my plan for incapacity. And here we're talking about, again, advanced healthcare directives, powers of attorney, kids protection plan, things like that. So page 8, my plan for incapacity select the best statement, or the statement that best describes your plan, and then go down and look at what is your plan for if you become terminally ill, if you develop an irreversible coma, or if you end up in a persistent vegetative state and you're not going to recover from that. Have you made plans and expressed your desires and wishes for how you want your life to be managed in that situation? So while you're doing that, we're going to take a look at a basic trust plan. So this is based actually on a plan that I did for a client. I've changed the names and taken all the personal information. This is a single client whose husband, I believe, has died, and she has 2 children. One has special needs and one does not. And so you can see here that we've created a trust for this client, and we're transferring assets into the trust, her residence, her bank accounts, her business interests, her certificates of deposit, all of that. The trustee becomes the new owner of those accounts for her benefit. So she still has full control over all those assets. We also address her life insurance, annuities, IRAs, and those types of things. At her death, all of her assets are marshaled, are collected. And you can see ultimately, and I'm going to put my cursor on the screen here, she wanted 50% or half of all of her assets to go to her child with special needs, but we created a special needs trust for her child. And we're going to talk about that in just a moment, but that's what will protect her child's eligibility for benefits in the future. Then we took the other half of her assets and we gave it to her neurotypical child. We placed it in a lifetime asset protection trust. This trust protects those assets from future divorce, bankruptcy, credit problems, lawsuits, things like that. So those assets have minimal risk for being wasted. Sorry about that. And you can see here that we even make plans for when these children die, whether these assets go down to grandchildren or over to the sibling. Right, so that's just a very quick diagram of how a trust might work in your situation. So let's move on and let's talk about that special needs trust right here. We're talking about that special needs trust that we created, and let's look at how that works. So that's actually critical step number 4. If you want to protect your child's benefits for the rest of their lives so they can receive SSI, SSDI, Medicaid, Medicare, SNAP, those things in the future, then a special needs trust is probably the best tool that you can use to ensure that. So here's some of the benefits. You get to manage your child's resources while maintaining the eligibility for government benefits. And if you should die or become incapacitated, then the person that you name, somebody you trust, will take over managing your child's resources and maintain their eligibility. And to make this really easy, there are several different types of special needs trust, and we're going to talk about those very quickly. So there are 3 types. There's what we call a self-settled special needs trust, or first party, a pooled special needs trust, and a third-party special needs trust. Now, a self-settled or first-party special needs trust, this is if your child has gotten assets, for example, through maybe they had an accident and they had an insurance payout, or they have, for some reason, maybe somebody left them a lot of money and now they're going to be ineligible for benefits. They can actually create their own special needs trust to manage those benefits, name somebody else to manage those assets for them, and then regain eligibility for benefits. Here's the problem though. If that person dies, if the person with disabilities who's established a special needs trust dies, Medicaid becomes the first creditor. And then Medicaid can come in and repay everything they've paid out in the care of your child with special needs. So if that's a significant trust amount, much of it or all of it could go to Medicaid when your child dies. The other kind is the pooled special needs trust, and this is often true with people with fewer resources. A nonprofit organization approved by the state creates what's called a pooled trust, where you can take whatever assets you have, and it's like a pooled investment where they take everything, they invest it, and then your trust has a proportional share of that investment for your child with special needs. Same rule applies though. Medicaid can come knocking on the door when your child dies, take back their share, and typically anything left over will go to that nonprofit organization to help cover their costs for future pooled special needs trust. Now, the third party special needs trust is often the kind that we create for clients with children with special needs. And this one, you as the parent or grandparent or somebody else actually creates a special needs trust for your child or sibling or niece or nephew or whoever it may be. And you place assets in that trust for your child's benefit. And the great thing about it is that Medicaid is not a creditor to this trust. So you can have $20 million in there, and when your child dies, Medicaid doesn't get a penny of it. And so, lots of choices here. The key is you must use the right special needs trust, and it must be drafted correctly, or it may not work. And the Social Security Administration may refuse it and say, nope, sorry, this doesn't work, and now this is an asset for your child, and we're going to deny benefits. So it's absolutely imperative that you speak with a knowledgeable attorney when you're setting up a special needs trust for your child. Now, one of the great benefits of a special needs trust for your child is that those assets are protected against things like creditors, against lawsuits. If your child is high functioning and gets married and maybe gets divorced later, that future ex-spouse doesn't get access to that special needs trust and those assets. And obviously the biggest benefit is that regardless, it helps maintain government program eligibility for your child. So if you haven't done so already, look on page 9 and complete step 4, where it says establish a special needs trust, and choose the statements that are true for you. All right, so we're almost towards the end. We're going to look at the last step. And the last step is that you can pass on more than just your money. So up to this point, we've talked a lot about legal documents and legal terminology. And I want to shift gears and talk about what truly matters. Hands down, at the end of the day, what truly matters. When it comes to your estate plan, absolutely the legal documents matter. You must have a solid, tailored, personalized legal documents to create your estate plan. But ultimately, at the end of the day, while you're a family, will appreciate that in that moment you did an estate plan, what they're going to want for the rest of their lives is something to remember you by. You know, my dad died over 20 years ago. And I was telling somebody just the other day that it's kind of sad because I can't remember his voice the way I used to. And I have pictures of him and I can remember what he looked like, but I can't hear his voice. And I had a very special relationship with my dad, and we I grew up as a child just hanging out with him all the time. And now I can't remember how his voice sounds. And I'd give anything sometimes just to be able to play a recording and hear him talk to me again the way we talked so much before he died. So while we talk about this, on your worksheet, page 10, pass on more than just your money. I want you to start thinking about other assets that you have besides your money. I want to ask you, what do your loved ones care about most? And if you don't take the time to capture the ways that your loved ones can remember you by, at some point, just like me, they're going to feel lost without you. Now, I can assure you, they're not going to take your will and place it on their nightstand so they can remember you. So what is it really that your loved ones care about most? What would they be most appreciative of and most thankful if you took the time to do? So think about your human, intellectual, and spiritual values. And you can look on your worksheet there. What's important to you in those areas? You think about, what are those memories that your family will most want to remember about you? What are the stories that you told growing up, or as your children were growing up, that they love to hear you tell? Capture those, write them down, record them, do something, because those are the things that your family is going to want to remember. How will they remember how you love them when you're no longer with them? Find a way to capture that. We often use videos and interview our clients so they can express their expressions of love for their family, and they can see the expressions on their face. They can hear their voice as they're talking about it. Here's one that's really important if you have a child with special needs. Instructions for the care of your child. How will your child's guardians and caregivers and caretakers care for your child when you're no longer there to do it yourself or to make sure that they do it correctly? That has to be memorialized either in writing or in video or audio in some way. We need to get that stuff written down so that your child with special needs has the benefit of you passing on this asset that is so much more important even than. So kind of underline this, how will your child remember you? Now remember, your child may be 10, your child may be 60 when this becomes relevant, but no matter how old they are, how will they remember you when you're gone? So I want to have you ask yourself 2 simple questions, and this will kind of help you as you move forward in this process. Up to this point, what do you value most about your life? What are your accomplishments? Your relationships? What kind of defines you in your life up to this point? So think about that. Maybe make a note somewhere about it. And then the second question is, if time or money were not an issue, what would your future look like? If you had all the time in the world, you had all the money in the world, what would your future look like? And this is broken down. What would it look like for you? And what would it look like for your family after you're gone? So the point of that is to say, up to this point, you have a legacy. Now, when you ask yourself that question, maybe it's not the legacy that you want to leave your family. Maybe you look at that and you're like, oh, I want more. I want something different. And the good news is you can start right now creating the legacy you want your family, friends, and community to remember you by. And this can be done in many ways. Again, letters, videos, conversations with your family, creating memories with your family, your friends, and your community. The most important thing is that you actually do it. Whatever it is, however it is that you want to change or create your legacy, you got to sit down and do it. And then when you look at your future, the same thing. What does your legacy look like? How will your community, how will your friends, how will your family remember you? What will your eulogy sound like at your funeral? And if your life today does not match up with what you envision for the future, start changing it. And we can help you with that. And we can give you lots of counsel if you sit down and talk to us about how to actually create the legacy that you want. Because I don't feel like I'm serving you well if I just draft legal documents and don't even address the fact that your legacy is more important than what you just did in those legal documents. So really, that's what I see as my purpose in life, as an attorney, as a parent, as a son, as a husband. This is the reason I'm here, helping clients and their families get an estate plan in place, plan for their children with special needs, and begin to create and capture their legacy while they're doing it. So a couple of things to think about as you create your legacy. Financial. Do you have a business that you want to pass down to your children, or do you want to be able to sell it so they can support your children? Maybe you can start a family foundation and teach your children the fundamentals of being a business person and making financial decisions and being what's the word I'm looking for? Charitable in their community. Maybe it's through setting up an estate plan or through a special needs trust. The second area where you can begin to create your legacy is through intellectual assets. What knowledge and skills do you have that you are passing or that you will pass on to your children, that you boost their intellectual abilities and they remember, mom or dad taught me this. Social, from a social standpoint or societal, we often say, are you creating relationships for your children that will assist them as they become adults to be successful? For example, if you have business associates, maybe take your child to a business gathering or a meeting or a conference and begin to introduce them to the people that make a difference in your life. And as they become adults, now those people know, oh, that's John's kid. I'm going to help him out. I mean, I've watched this kid grow up. I know his dad has been teaching him things. And now that his dad's gone and he's, maybe taking over business, I want to be there to help him out. Social capital, social assets. The human assets. Again, it goes back to what are those stories and wisdom and life experiences that your family, friends, and community will remember you by. And for some people, it's the spiritual. And I'm not talking about religion. I'm talking about this, in the spiritual world, whether it includes religion or spirituality or whatever your belief system may be. What kind of guidance are you providing for your family? And what kind of example are you creating to your community at large? Okay, so these are some ideas to think about. We call this the FISHES system: finance, intellectual, social, human, and spiritual. So some things to kind of give you some guidance as you think about this. All right, so thank you so much. Just a quick recap. We've talked about these 5 critical steps. Choose the right guardians for your children. Keep them out of the homes of strangers. Provide enough financial resources. That was the second underlying principle that we have to adhere to. The third principle was passed on more than just your assets, but that includes passing on your assets. So we talked about preparing a revocable living trust and the related documents. We talked about creating a special needs trust and passing on more than just your money. So what I'd ask you to do as we come to the end of this is go to page 11 in your workbook. At the top of the page, there is a box and it says My Truth. And I would like for you to click or select one of those boxes. And either after listening to this, you say, you know what, I need to schedule a special needs life and legacy planning with John and his team because there's a lot of things I need to take care of. Or you may say, you know what, I've done all this, I'm happy with it, I've done a good job, thank you for the education, and and you walk away feeling good that you've done what you should. And then if you feel like there are things that you need to address, I want you to look down to where it says My Promise. And this is the promise I want you to make to yourself, not to me. I promise to take the necessary steps to ensure my child with special needs is cared for the right way and my family stays out of court and out of conflict in the event of my incapacity or death. Make that promise to yourself and then sign your workbook to memorialize your promise. I'm putting my name, my signature to this because I am making a promise to myself that I intend to keep. Pardon me. So now let's go back and look at why you're here. On the first page of your workbook, I had you write down the names of the people that would be affected in the event of your death or disability, that your children with special needs specifically. And they're the ones that need your protection. You can see on the screen, these are the people that I care about, the people that need my protection. And this is why I did my plan to make sure that they were protected, that my child with special needs will always be protected and still be eligible for his benefits, that I'm leaving assets to my children and to my grandchildren to make sure that they're cared for, that if I die first, my wife is cared for as well. Now, they rely on me to do that for them. They relied on me to put in place the legal documents to protect them. But even more importantly than that is the legacy that I'm going to leave behind for them, the legacy I'm building for them every day. And your loved ones need that too. So we've gotten through the most valuable lesson. The good news is you don't have to do this alone. There is help. But let's talk about how we can get an estate plan in place to protect your family. Honestly, you have two options. They're not equal, but you do have two options. Now, the first one is you could go online to one of the online wills places, or you could go to that lawyer down the street who does everything in any kind of law and doesn't really understand special needs planning and estate planning, because it looks simple. But what we understand is that it's not always simple, and often there are mistakes made and it becomes ineffective and doesn't work when your family really needs it. So the other option is to go through a route and a process that's tailored and personalized, where you sit down with an attorney like me. I listen to your story. I incorporate everything I can learn about you, about what you want, about your family into your estate plan, and I make it very comprehensive and personalized. So the traditional experience in working with a traditional attorney, if you've worked with an attorney, you can probably identify with this, is an hourly billing model. You really don't know how much it's going to cost at the end of the day. A 1-minute phone call or an email can result in a bill for 6 minutes or 15 minutes, and it only took a minute to actually have the conversation. And so, essentially you're getting billed for a lot of time that isn't actually used for your benefit. And so much about the traditional practice of law is that it's designed around a knee-jerk response to problems. A problem falls in your lap, you get into a dispute with another party, you react to that problem, and you go see an attorney. The attorney says, well, we can do this or this, and this is how we're going to handle this. And at the end of the day, everything's finished and you were a transaction. But what if you had actually planned ahead of time so that your family isn't going to see a probate attorney saying, my mom, my dad just died and they didn't leave a will, they didn't leave a trust, whatever. I don't know what to do. I don't know what to do with their house. I'm not, they had a business. What do I do? And now you have limited options because there was no planning in place. And those are options that probably aren't best for your children because, they're having to respond after the fact. So what's the alternative to that? Well, I looked at this and I flipped this traditional experience on its head. So everything I do is flat fee, agreed to in advance. You don't have to worry about every little phone call and email because we don't keep track of our time. You may have a million questions about your plan, and I promise you, we've had clients that call us every day, multiple times a day, and that's what we're here for. We're here to answer your questions and ultimately help you make sure that your plan is exactly how you want it. Plus, I love that personal interaction with clients on the estate planning level because it's proactive, and we're addressing your questions and we're making sure that your plan truly reflects your desires and it's customized to you. So when you ask questions, that tells me you're thinking about it and you want to make sure that that plan works the way you want it to work. And by planning ahead, we're not in that reactive knee-jerk situation. We're being proactive. And so it's all about deciding ahead of time that you want to avoid that reactive scenario later for your family. And so for me, I really value these ongoing relationships with the clients. I enjoy staying in touch with my clients over time. I know that your estate plan needs will change. This is not something you do one time, throw it on a shelf and forget about it. The law will change. It just changed in 2020. It changed in 2019. It will change again. and your estate plan has to be kept up to date with those law changes, or it may not work when your family needs it. And your family, your life experiences and situations will change, and you need to make sure that your estate plan changes with your life. And so my experience with clients is we stay in touch, we address those changes year after year to make sure that when your family needs it, your plan actually works. So here's our promise to you. We promise that your estate plan will leave no stone unturned and will give you the peace of mind your loved ones and assets are kept out of court and out of conflict. Okay, and so that's our promise. Let's talk a little bit about our process. It's a 3-meeting process to get your estate plan in place. The initial meeting is called your Special Needs Life and Legacy Planning Session, where we sit down one-on-one together and talk about your plan. Now, in advance of your planning session, you'll be asked to complete an online life and legacy assessment, and that's how we get key information about you, your family, and your assets. It's completely secure, it's easy, but it's really important information that I review in advance of our meeting. At your planning session, we hit the ground running. I'll be asking you questions, you'll be asking me questions. Ultimately, we'll decide on what the best plan is for you based on having educated you and given you the information you need to make that decision. And we can start designing your plan usually that same day. I go over the engagement agreement. We agree on the plan, sort of flat plan, and then we make arrangements for payments at that meeting. And then 4 weeks later, we get back together and we sign. Now, this is when your plan becomes legally in place. It's the big day. We had, clients come in with, wine and cheese or champagne to celebrate because they got everything in place. All your wishes are expressed, your desires, everything is captured in these legal documents. And at this signing meeting, typically we ask you to pay the balance of the fee, but we do have some other options available for some people who just can't swing that. And then we come back about 3 or 4 weeks later and we do your final meeting. And this is where we focus on some of those more important aspects of your plan. As your family grows, as it changes, we talk about how to move forward with that. And we talk about capturing your legacy and creating your legacy. And so, this is where you are creating something, and it's not something you create one time and forget. It's a living creation that keeps going on and on throughout the rest of your life. So at that point, what we expect is that you have that peace of mind, and along with taking home your estate plan and its beautiful binder and its beautiful paper, the most important thing you're taking home is your peace of mind. So thank you so much for giving me this opportunity today to educate you about these 5 critical steps, about our process. And as promised, you stayed with me to the end, and I do have a gift for you. So typically, I charge $750 to meet with a new client for 2 hours of education and information that empowers the client to make the best decisions for their family. But you spent time with me today, and as a thank you for that, I want to give you a gift certificate to allow you to have that 2-hour meeting with me at no cost. So it's a $750 gift certificate. And on top of that, I would like to give you another gift certificate of $250 off of a special needs trust. Now, typically, when you create an estate plan with us, a special needs trust is an additional $1,000. This is $250 off of that as my gift to you. But I need you to respond in the next 24 hours. I need you to go to our scheduling link. It's HiltonLawPLC.com/schedule online. I'm going to put it up. Patricia will put it up in the chat box. So you can just click on that link and go straight to our scheduling page. And if you'll put in the promo code 5 steps. That's the number 5 steps at the promo code. And I'm going to show you here in just a minute how to do that. Then we'll make sure that you get these 2 gift certificates for $1,000 towards my services. So here are your next steps. And I'm going to show you very quickly how this works. I'm going to click on the link. This is the hiltonlawplc.com/schedule-online. And again, Patricia will be putting that up in the chat box, so you can go straight there with me if you decide. So I'm going to click on that link. And you should come to this page. It says Law Office of John K. Hilton, Schedule Online. And if you scroll down, you'll have 3 options, and you're going to select this middle option, schedule a 2-hour life and legacy planning session. So I want you to click on that link, and it'll bring you to this page. And on this page, read everything there. You get down to this section. Fill in your name, your first name, your last name, and your best email. And then you need to come down and you need to agree to these conditions. You're going to agree that you will complete the homework that we're going to send to you before you come to the life and legacy planning session. That if you're married, that you will make sure that both you and your spouse come to this appointment together, because I really cannot give you advice unless both of you are there to discuss and agree. You're also going to agree that you will give our office at least 7 days notice if you need to reschedule or cancel your appointment. So you're going to click, yes, I agree. Yes, I agree. I agree. And then the last one, it says that you understand that we're waiving that $750 fee, and that, but if you fail to keep any of your commitments above, then we can charge you that $750 when you come to the appointment. So you just understand that this is 2 hours of my time. I don't see very many clients every month because I like to keep it personal and intimate with my clients. I can keep that relationship with them. So when I give away 2 hours of my time, it's a valuable 2 hours. And so if you abuse that, if you don't show up, if you don't do the couple of things that we ask you to do, then you may be charged that $750. So click on agree, and then right here, go ahead and type in 5 steps. Whoops. Let's do it with the 5. 5 steps. Doesn't matter if you use uppercase, lowercase, it'll still read it, and then click on the bar that says go to the online scheduler. By doing this, this gives you access to our online scheduler, and you can pick the time and the date that works best for you of the available slots that I'm available to meet with you. All right. So then schedule it and go ahead and bring your gift certificates to your meeting, and we will move forward with training, education, empowerment, and getting your plan in place. So thank you so much for attending. We are going to address any questions that come up now. So let's see, how much time do we have? Oops.
Hey, John, I do have a question. It's Patricia. Can you hear me?
I have no idea what that is. Oh, somehow. That is so funny. Somehow
it's captioning
doing,
doing closed captioning.
All right, well, we can leave closed captioning on. That's okay.
So, John, I have a question. It says that I'm in the process of getting divorced, but we're in an agreement that we need.
We're going to check out the question box. Patricia, are you there? Do you have any questions for us?
Yeah, John, can you not hear me? Let me.
Hello, Patricia, are you there?
Yeah, can you hear me? John, can you hear me? I guess my audio is not working.
Okay, I think I can find Patricia now. Sorry about that.
It's okay. Can you hear me, John?
I can hear you.
Okay, great. So one of the questions is, I'm getting feedback, I think. I'm on the process of getting forth, but we're in agreement that we need to take care of this soon. How does that work?
Okay, excellent question. So I assume you're working with a family law attorney with your divorce. And my recommendation is that if you are not, that you work with a family law attorney that understands special needs planning. We actually work with an attorney who does a lot of special needs divorces because there are a lot of issues that must be addressed when it comes to parenting time and child support and things like that. On a larger scale, what I often will recommend is that both parents set up a special needs trust because very often it's difficult for one parent to give up control of the trust to the other parent if they're placing assets in it. So it's a very specialized or individualized approach. What I would recommend is, we sit down. We can sit down as a couple who's in the process of a divorce and kind of talk about options. I would not be able to represent both parties, but we can at least kind of talk about a plan and then, work out how to proceed from there.
Okay, I have another one. Can I still preserve my child's eligibility for benefits if I don't establish a special needs trust?
Yes, in some ways. But it's, I would absolutely require that you get guidance on how to do that. It depends on how many assets you have. One way to do that is through the ABLE account. However, there are, pros and cons with using an ABLE account, such as if your child dies, anything that's left in there would go to Medicaid first. And so there are options, but they may not necessarily be the best options for you.
Okay, here's another one. And this individual has an adult child with special needs and is wondering, how do they know if their adult child with developmental disabilities needs a guardian?
It's not a simple answer. It's a great question. It's one that people call in our office frequently. Sometimes they just say, I need to have a guardian for my child, my adult child. He's turning 18. And then we sit down and talk about it, and we discover that really the child doesn't need a guardian. It needs an alternative. So we go through a process. Really, it's difficult unless your child is obviously semi-independent, is working. We have a client whose daughter graduated college and is independent and working. She does not need a guardian. Most of the time, it's not so clear cut. And so we kind of go through a process of digging into what specifically that child is capable of doing or not doing, and whether they need a full guardian, maybe they need a limited guardianship or not. And so it's really difficult to address straight up if A and B equals C, then yes, you need a guardian. It's much more complex than that, but it is a process of really exploring the child's capabilities.
Okay, great. Hey, there's one more here. This attendee is asking, what if I have a family member that I would never, in all caps, never want to be a guardian of my child? How do I handle that?
Boy, that actually comes up more often than you would think. So it's a great question. And what I recommend to clients is basically there are two situations in which that may occur. Most often that comes up when the person who would never be considered to be a guardian is actually someone that they don't want them to know about it. And so as we're putting together the guardianship papers and the kids protection plan, getting all of that legally documented, one of the things that we can do is actually create a letter of exclusion, and where we list the person who should never be a guardian of that child. Sometimes it's because they are a known sexual predator, or they've been known to use drugs and alcohol in the home, with the child present, and expose the child to dangerous situations, that type of thing. And so we list that person, and we list the reasons they should not be considered for guardianship. We put that in a sealed envelope with your legal documents. So if that person ever does come to court and say, I want to be the guardian of my nephew or my son or daughter or whoever it may be, and that that's a terrible choice, then we can give that letter to the judge, where the judge can read it in private and then know that, wait a minute, this person may have some things we don't know about, and they can initiate an inquiry into that person's past and take all of those things into consideration when making their guardianship decision.
So Don, this looks like it's probably a two-part question. So this person wants to make sure that their child with special needs can always live in their house after they die, but is wondering if they can transfer that house into their child's ABLE account.
So, yeah, to answer the first part of that question, yes, there is a way to ensure that your child can live in your house the rest of their life. And that would be through some careful trust drafting. Two considerations there: one, to make sure that house is always available for your child, and secondly, to make sure that having that house available for your child does not disqualify them from benefits. The second part of that question is no. An ABLE account can hold cash, but it cannot hold physical assets such as a home.
Okay, well, we have an attendee that might be having a baby. It says, congratulations. It says, is there a way to expedite this if I'm about to have a baby?
Well, congratulations. and yes, absolutely, we can do that. So, this comes up, maybe you're about to have a baby, or maybe you have a parent who's on hospice, or maybe you're on hospice. You're like, I need to get this done right now. I don't have much time left. I want to make sure I've got a plan in place. So we do have a process whereby we can expedite this process. Now, you saw earlier, typically it takes 4 weeks to get to signing and another 4 weeks to get your documents. But we do have the ability to get this done in a very short amount of time. Absolutely.
So this attendee wrote, you talked about meeting with a financial planner, but how do I calculate how much money my disabled child's gonna need through their lifetime?
That's a great question and a difficult question. Pardon me. Like I mentioned before, most of us grossly underestimate how much it's going to take to care for our children throughout their lives. And I have a friend who is a special needs trustee for Special Needs Trust, and we were just talking about this a couple of weeks ago. And she said that she has a lot of special needs trust that are valued at like $1 million, and they're going to run out of money before the child or the adult dies, because they have a life expectancy of 75, 80 years, and they have medical costs, and they have housing and food and transportation that all have to come out of this trust. And so, that may not be true for everybody. Everybody's children are going to have different needs. So the only way to know is to do that life care plan. And my recommendation is that you go talk to a reputable life insurance provider who specializes in life insurance for families of children with special needs. And I know for a fact, for example, in Tucson, Arizona, they have a department specifically for families of children with special needs, where they create and craft life insurance plans for them, and they will do the life care plan for you and help you calculate over the course of your child's lifetime, based on their diagnosis and other known and unknown variables, how much you should plan for to care for your child.
Okay, this person said that I don't have a very large of an estate. Do I still need to do a trust or question mark?
That's a great question, because one of the misconceptions out there, and you hear this from a lot of financial planners and traditional attorneys, is that, well, if you don't have an estate worth at least $500,000, you don't need a trust. You should just go with a will. Or maybe it's even $100,000, is the threshold. If you have less than $100,000 estate, you should just do a will and not a trust. And the reality is that there is no one threshold that's right for every client. So what I prefer to do, and what we do in our office, is we prefer to educate our client about how a will works, about how a trust works, and how the court, the probate court, looks at a will, what would happen in the event of a will, what would happen in the event of the trust, and let our clients make the decision about what is best for them, a trust or a will. And it's not based on any arbitrary net worth threshold, but it's based on having the proper education about how either option will affect their loved one's experience when the client is no longer there. So for us, it's much more about the quality of the experience for the loved ones rather than some arbitrary random dollar amount to determine which is best for you.
Okay, this attendee says, I already have an estate plan. How does that fit in with what you're offering?
Yeah, so we have a lot of clients come in who have a trust or a will, and so the first thing that we would do is during our preliminary process, we'd ask the client to send us a copy of any estate plan documents that they have, and I take a look at those. And then during our meeting, I discuss those documents with the client and determine if they truly represent what the client wants. We've had some situations where the client says, you know what, everything I have in place is still exactly the way I want it. I don't want to make any changes. We're like, great. We're glad that we could reassure you that your plan is up to date. And the client leaves and we don't do any more work for them. Other times the client will tell us, no, there are things I need to change. This is not what I want today, even though it's what I wanted 5 years ago or 40 years ago sometimes. So then we look at things and we make changes. But if the client already has documents in place that absolutely reflect their current wishes, there's no need to recreate those documents and necessarily make new ones. So if there are absolutely no changes and they still reflect the client's wishes and they're still current, then we can make some minor adjustments to the fee, because that's part of what we're not going to be doing. But honestly, those adjustments are not significant, because most of the value that we give our clients is in the counsel and education and knowing that they have a plan that will work for them today and throughout the rest of their lives.
Okay, John, we have someone who has a neurotypical child and a couple children with special needs. Would they need to have a living trust and then a separate special needs trust for each of their special needs children, or how would that work?
So typically, and again, we make this decision only after sitting down and looking at the client's resources and assets and really determining the functionability of each of their children and what their future needs are going to be. But assuming that both children have significant needs and both children will need eligibility for benefits throughout their life, then we would definitely like I said, we would probably recommend that each child have their own special needs trust in order to ensure that it's compliant with the Social Security Administration rules for eligibility. And then depending on the client's resources and assets, we would help the client decide whether a living trust is right for them or a will or what other kind of estate planning is appropriate.
Okay, I think we have time for one more question. I'm not seeing any more questions, John. About how long, I don't know if we mentioned this, how long does a life and legacy planning session take? And what are the payment options that we have?
So we set aside 2 hours for a special needs life and legacy planning session. And you're welcome, there are times we get through that in less time. Sometimes it takes longer. You're welcome to use as little or as much of that time, 2 hours as you like. Our goal is to make sure that when you leave that 2-hour session, you are fully educated and informed to make the best decision for you and your family. So the only way we can do that, though, is we ask you to do some homework ahead of time that allows us to be very efficient in the use of our time. So if people who don't want to do the homework and they want to come in, it's going to take much longer. And I actually charge the $750 for that meeting if I have to do the homework for them in that meeting, because we're going to need probably another, a couple of hours just to get through the education. But you come in fully prepared. I'm prepared. We ask questions, you ask me questions, we review all your options, and we can typically get all that done within an hour or two. If during that meeting you want to move forward and go ahead and get your plan designed, we do it right then. So when you walk out, we've already created the first draft of your design, and then it's just a matter of cleaning it up and getting it drafted and ready to sign in 4 weeks. So you make a lot of initial decisions during that first meeting. So for the payment options, what we typically ask for is the 50-50 option, where you pay half of the fee during that first meeting and half a month later at the design meeting. Now, we do make other accommodations from time to time for clients, and most importantly, we also have a very easy financing option if that's best for you. For some clients, that may be easier just to finance the whole fee, pay it off over 6 months or a year instead of trying to come up with the full amount at once. So you get to choose the option that works best for you.
John, it looks like that's about it. I'm not seeing any other questions. I was going to put in the chat box a link to our Special Needs Freedom Guide.
Oh, that would be awesome. Yeah, okay. Please do that.
Yeah, let me do that. I can get it to work.
Okay, so while she's doing that, everybody, don't forget, if you go to the chat box, Patricia has posted there a link to our online scheduler. I showed you how to go through the form and to get onto our scheduler. So please do that. Please be sure and put 5 steps in the promo code so that you can get those certificates, $750 towards that 2-hour meeting with me, and the $250 off of a special needs trust if you decide to work with us to do that. And then I believe that Patricia is trying to get the link.
I'm trying to.
So if you know what, if she can't get a link in there, if you go to our website, HiltonLawPLC.com, there's a link on our website, and it's a Special Needs Freedom Guide. And it talks about the 5 critical steps that I've talked about today, but it also goes into a lot of other things that you need to do to make sure that your child with special needs is cared for. For example, it talks about how you need a real team of advisors, and I absolutely adhere to that. You need a a financial planner, a life insurance agent, an attorney. You've got all your care team. It takes a lot of people to really make sure that your child is fully cared for throughout their life. So it's a great booklet. It's our our special needs freedom guide. If Patricia can't get the link up, that's fine. Go to our website and you'll find it there.
Okay, I did get it up
Awesome.
in there. I'm also going to put our scheduling link again. And I think that's it. I see no more questions. So thank you all for joining us today.
Yes, thank you all. And thank you, Patricia, for sitting back there and making all that happen. Right.
You're welcome. Very welcome.
Sure. If you have any questions, there's a link on our website where you can email us, or you can email us on your screen right now, clientservices@hiltonlawplc.com. That actually goes straight to Patricia, and she can either answer your question or she can route it to the right team member to ensure that we get your questions asked. So please don't hesitate to email us any questions you might have. All right, so I think that we have reached the limit of our time. Thank you, everybody. Hope to see you in the future.
Thank you.